May it please the court, Neil Lane with Northern Rose Fulbright on behalf of Church Mutual. I want to focus first on two problems with the verdict that led to the judgment here that are simple and immediately recognizable. They were not corrected in the district court, and they should be corrected on appeal. First, the jury clearly included the amount of the plaintiff's deductible in their award of contract damages. Now, Church Mutual isn't challenging the award of the contract damages except to the extent of the deductible, which is the uninsured portion of the plaintiff's loss. The amount was in the record, it was undisputed. The plaintiff is never entitled to receive its deductible as contract damages because the plaintiff's never entitled to payment of the deductible under the policy. It's the uninsured portion of the risk that the insured retains. That's why courts routinely reduce the amounts of awards by the amount of the deductible. If you look it up, there are innumerable cases. It's true that there's no case that reverses for failure to do so, but there are innumerable cases where the courts routinely reduce the amount of damages by the deductible. That's the first point. The second point is, while we believe that the evidence showed nothing more than a bona fide coverage dispute between these parties below in their dealings with each other, the jury awarded damages for statutory violations and for bad faith that are not independent from the amount of policy benefits that the plaintiff was entitled to receive. We believe that rather than offering proof of an independent injury, independent from the contract claim, the plaintiff asked the jury to award the alleged cost of repairing the plaintiff's roof, $804,000, in response to every damages question. In response to all of the damage questions, they were urged, answer $804,000. There was not even a pretense that there was some independent injury that was occasioned by the conduct of the insurer. Did you say the damage, the interior damage? That would be covered by the policy. If there was interior damage, it should have been included in their claim, and that was referred to, but it was not actually asked for in their roof repair claim of $250,000 or their replacement claim of $800,000. So that was an issue that was raised, it was discussed, but was never actually, it would have been a policy benefit because it's a property claim. If you tear open, if a hole opens in the roof under the policy would cover repairing the roof or replacing the roof if the evidence had shown that. And then it would cover whatever the damages are inside, and that's still a policy benefit. Without any evidence or guidance, the jury awarded several different amounts that were not tied to any figure other than, according to plaintiff's counsel, the plaintiff's deductible. The plaintiff in their brief suggests that the amount of the deductible is a good starting point for calculating damages for the insurance code and for bad faith. They say, well, the $56,000 was close to the deductible, and if you look at the $29,000 that was awarded in two places, that's roughly half of, each of those is roughly half the deductible. That's not the argument we're making, that's the argument the appellant makes. But rather than being a good starting point, I would suggest to the court that that's quite the opposite. It's a stopping point. The first rule in Manchac is that an insured cannot recover policy benefits for an insurer's statutory violation if the insured does not have a right to those benefits under the policy. The plaintiff did not have the right to the deductible under the policy.
Let's go back to point one, I guess, about the deductible.
Yes.
Where's your evidence? Where's your support for the idea that the jury didn't consider the deductible?
Oh, I believe that the jury considered the deductible.
Sorry.
Because they actually sent a question during deliberations as to how it should be treated. The deductible was actually in the policy that was admitted into evidence. They were keenly aware of the deductible. They asked the court, well, what do we do? Do we award?
But how do we know they didn't include it in coming up with the $285,000 figure?
Well, $285,000 was the cost of repair that was put forward by the plaintiff. They had and separately from the cost of replacement. They said to repair the roof would be $285,000. That's the total cost to repair. That is not the insured amount of the loss.
But we're just supposed to suppose that they didn't award some higher amount and reduce it by the deductible.
Well, there's no support in the record for that, that there's $285,000 plus $57,000 and some number floating out there, and that they then reduced it to come back exactly to the cost of repair that was put forward by the plaintiff.
But we owe substantial deference to a jury verdict.
Oh, we do.
How do we get around that, though?
Well, there's then substantial deference is not without its limitations. The evidence still has to support the verdict. And in this case, the evidence was, there were four pieces of evidence, if you will. There was one, the original estimate, an exactimate by the independent adjuster, $53,000. Then there was a Syntex bid that was to replace the roof with a warranty and everything by a real repair person. That was $43,000. Then there was a $285,000 figure, which was the cost to repair the roof that the public adjuster for the plaintiff put forward. And then there was $804,000, which was the cost to replace. Now, the insurer had actually hired an independent adjuster almost as soon as the claim came in. The independent adjuster hired an engineer who took core samples and actually tried to determine whether the roof needed to be repaired and concluded that it did not. There was someone else who came in at the request of the plaintiff, did other estimates, put forward other evidence, and that's where the $285,000 evidence comes from. But there was never any submission to the jury or in evidence that there was some number that you could deduct the deductible from, and you would get down to $285,000.
Well, so I guess that's the question. Is this, are we supposed to look at these different amounts as discrete points? In other words, you could award $43,000, you could award $285,000, you could award $804,000, or is it a spectrum, 0 to $804,000, and the jury could choose any amount along those ways? You see what I'm saying?
Yeah, I would say that the evidence wouldn't support a spectrum because the $804,000 was to replace the entire roof.
So the jury wasn't free to say, well, we think it's more than this $285,000 estimate, but we don't think it's as much as $804,000. We think it's this amount.
No, the only evidence
But isn't that what juries do all the time?
Juries compromise all the time, no question. But they compromise.
So what if they did that here? Does that mean it's invalid?
That means that in this case, the number that they came up with were not supported by the evidence in the record. And so your jury compromises.
How does the $804,000 amount not support whatever they might award below that amount?
Because the $285,000 is specifically the amount of the cost of repair that the plaintiff put forward. And there's no other way to interpret that. There's no way to interpret that as a half, one-third cost to replace the roof that they somehow came up with. I would add.
Well, I mean, the total damages was $400,000, which happens to be half of what the total roof replacement would be, right?
But that's not that doesn't reflect the evidence in the record. If we're there are
What's your best case? I mean, I know you talk about some cases in your briefing. I don't know that those cases say that a court is required to subtract the deductible once a jury comes back. What's your best case to support taking this logical leap? And your argument has logical appeal because of the $285,000 in evidence and the $285,000 they awarded, but what's your best case to support doing what you want us to do?
So I will say this, that there are numerous cases where the court, before it gets here, has already reduced it by the deductible.
Nobody argues the court couldn't have done so,
Yes.
But what's your best argument to say that the court erred by not doing so?
I would say that I can't think of the best case standing here because there's no case that actually where the error was, hey, you didn't reduce the deductible, because it's so routinely done. The fact that there's not been an appeal in that circumstance speaks more to the widespread acceptance of courts that you don't get the uninsured portion of the loss. But the fact that that the verdict should be based on the evidence of loss is clear, and that's a general principle. Now, I will also say that when it comes to damages under the insurance code or bad faith, I do think Menchaca whichever way you wish to pronounce it. Those who lived in Austin might call it Manchac, and those who haven't might call it
When I think of Manchac, I think of up the road and Kent,
exactly.
Menchaca.
Manchac. But in any event, the first rule says you can't recover as under the insurance code or bad faith. You can't recover the uninsured portion or an amount that you're not entitled to under the policy. And that's really that goes to the heart of our challenge to this $59,000, $29,000, $20,000.
Unless there's an independent injury, correct?
If there's independent injury, which Menchaca says is very rare, and the Texas Supreme Court's only upheld that we're aware of in one circumstance, and that's for mental anguish, which is not available to a non-individual plaintiff. There wasn't a claim for mental anguish here on behalf of an entity.
And bad faith be the grounds of an independent injury?
The bad faith also must be, in fact, in this court, in Weiser Brown looked at the underlying evidence and said that there wasn't evidence to support the insurance code or bad faith liability. Insurance code and bad faith damages are so closely identified as to be coterminous. But in any event, getting to Manchac, and I think we should talk about that somewhat. There are, as this court knows, there are 5 rules that were announced in Manchac, and as Judge Clement knows, there was some confusion to the point that the Fifth Circuit, on a panel that Judge Clement was on, Deepwater Horizon, said, "Please give us some guidance." They asked, the Supreme Court was prepared, and said the case settled before they could do so. But there are really 2 rules that are applicable here, and one is the rule number 2, the entitled to benefits rule, and that tells us that the plaintiff may elect to cover the amount of benefits that they're entitled to for a violation of the insurance code that they would otherwise get as breach of contract. That's an election. Why did they do that? Well, you get enhanced insurance. If there's a knowing violation, you can treble that amount, and that's the reason that is permitted, and that is actually Menchaca's attempt to make sense of the 30 years, 40 years of precedent, and that's what it says. But Menchaca rule number 4 provides that an insurer's statutory violation doesn't permit the policyholder to recover damages beyond policy benefits unless the extra contractual violation causes an injury that's independent from the loss of benefit. And it actually supports a case from the federal Southern District of Texas in Menchaca, where there was coverage and the plaintiff sought damages under 541 of the insurance code. And the district court rejected that for failure to show independent injury. And in Leidas-Winterton, in this circuit, this court concluded that in that case, the plaintiff proved its breach of contract, but failed to prove an insurance code violation because it didn't establish independent injury. So really the liability and the injury are closely tied. If you cannot establish the independent injury, you cannot establish the violation. And Leidas-Winterton refutes plaintiff's argument that the court can disregard the independent injury rule because policy benefits can be recovered under the contract claim and the statutory claim. It just flatly, that argument is inconsistent with the finding, the ruling in Leidas-Winterton. The opportunity for independent injury damages for violation of the insurance code and bad faith are very rare. We also appeal from the award of costs, and that relates to...
Before you leave the extra contextual damages, tell me what your position is, if you could, on questions 7 and 9. I mean, I think you take the jury instructions question by question. Are these, I guess the 3 jury awards, the 29, 29, and 57, are these separate claims, or was the church required to elect 1 or 2 of the 3? In other words, is there overlap, is there not overlap?
Is there an election within the election, in other words? In other words,
yes.
They can elect to receive the contract benefits or elect to receive the contract benefits as an insurance code award. And that is certain, but they cannot, I would say that there's no evidence that would support either 9 or, well, the damages that were awarded in response to 9 or 7, and that's dispositive. So the election issue really does not arise, because without an independent injury and proof to support an independent injury, apart from the loss of the proceeds, it doesn't matter whether they elect one or the other pieces of the insurance code.
Thank you, Counsel. You've saved time for rebuttal.
Thank you.
Mr. Ayers.
May it please the court, I'm Jonathan Ayers. I was the trial counsel on this case as well as the appellate counsel. And first of all, I would like to say it's my personal belief that this was a compromise verdict, without question. And to understand how the jury got to that point, it's important to talk about a few of the facts that led up to the jury deliberation. Indeed, the way this case got started was that this church has owned this building. It's an old Albertson store, grocery store. They've owned the building since 1998. As the pastor testified, they put a lot of sweat equity into this building, and they insured it to preserve their property through Church Mutual. This storm happened on April the 13th of 2018. They contacted Church Mutual, and Church Mutual, not a single employee, an actual employee of Church Mutual has ever set foot on this property. They hired a fellow by the name of Thomas Spillman, who lives in the Metroplex area, a couple of hours away, and he comes down, and this is the first gravel ballast roof this gentleman has ever been on for purposes of doing an adjustment. He looks at the roof, concludes that there's indeed hail damage, obtains a hail report that indicates that there's 1.75 to 2-inch hail at this location. He also concludes 60 to 70 mile-an-hour winds, and that there is clear damage to the ephes, to the metal components, to the signs. Clearly, this particular property was heavily damaged by hail. But he's not really good with these roofs. He thinks that there's damage to these roofs, but he makes his report to the carrier, and so the carrier hires their go-to guy, a fellow by the name of Marco De Leon, to go out and to look at the property. This piece of property is 200 yards by 200 yards. It's a big roof. Mr. De Leon limits his review to basically 2 10 by 10 squares. When I say 10 by 10, 10 foot by 10 foot. And he takes some samples. But Mr. De Leon never goes inside the building to look and to see where the damage is coming through the roof into the building itself, which leads to Mr. Dobbs' testimony, which this proves the independent injury, is the testimony of Mr. Dobbs, which I'll get to in a second. But with respect to what occurs in the handling of this claim, Mr. De Leon ends up doing an estimate, or a scope, if you will, which in turn Mr. Spillman uses to form an estimate. And the estimate just happens to be about $3,000 less than the deductible. And the adjuster in Wisconsin tells Mr. Spillman to take off overhead and profit, which reduces it even further, and then writes a denial letter saying that there's no recovery here for this loss. So at that point in time, the church makes a mistake. And their mistake wasn't hiring a public adjuster. Their mistake was having the public adjuster try to get some money to fix this property as quickly and as efficiently as possible. So he does a repair estimate for $285,000, which is called a scratch and flood procedure, where they basically go on and they put another coat on top of this roof. And the reason for this is, if you look at Mr. Dobbs' testimony, prior to this hailstorm, they had not had any interior leaks. After this hailstorm, and to the present day, because even though this carrier lost, and even though they acknowledge that they're responsible for some funds, they have never written a check for anything to Church of the Open Door. So to this day, for the last 5 years, every time it rains, Mr. Dobbs, as the maintenance man, has to put buckets out in the sanctuary, on the stage, under the soundboard, in the nursery, in the children's room, in the offices. Yet Church Mutual never looked at that damage at all. Instead, the damage is so widespread, Your Honor. It's widespread, and it comes in one spot, and it goes through this type of substructure, and it goes to different areas. So we would basically have to tarp the entire building. But
Well, so, not to cut you off, counsel, but I mean, the facts are interesting, but we're past a jury verdict at this point. I kind of ask you the converse of what I asked counsel opposite. The jury comes back with $285,000 as the main award, and it does happen to match the estimate that was prepared by your folks for repairing the roof. So what does support the idea that they didn't, or they considered the deductible in arriving at that number?
Well, and that's exactly where I'm going next, Judge. The facts of the matter are, after Mr. Hastings, the public adjuster, did this estimate, he brought out an engineer. The engineer brings out another engineer to do testing. And both of these engineers discover that there's water saturation under certain spots. And that leads to the big controversy in this case. And I think, honestly, the real controversy and the real reason for the compromise verdict. Is it a roof that can be completely repaired? Or is it a roof that needs total replacement? And I think that was the struggle that the jury had, because these saturation points are only in certain locations. And so, as Judge Albright said in his opinion, supporting the judgment, the range, if you will, was from $43,000, which is what Church Mutual says the damage was, all the way up to $804,000, which is a total replacement.
So your position is not surprisingly different than what counsel opposite said. This is a spectrum or a continuum, not discrete points on that continuum. 43, 80, 285, 804. The jury was free to find any number from 0 to 804, or 43 to 804, whatever.
Absolutely. And the cross-examination.
But don't they have to have evidence to support what number they come to?
Well, they do have evidence. The evidence is that a simple repair would cost $285,000, but a replacement, a full replacement, would be $804,000.
But if they awarded you the money for a simple repair, $285,000, why then is counsel opposite not correct that the deductible comes off that amount?
Because the evidence was there was damage underneath, that a simple repair would not do the trick.
What was the quantification of that damage? Was that how we get to 804, or is there some other number?
Well, that's just it. There was never a specific number, but the argument was made that some portions of the insulation could be taken out, some portions of the substructure could be taken out, and that you could do patchwork, basically, of certain areas. But there was never a specific number given as to what those areas were, which is why I think the jury compromised the way they did on this broad range, which brings us to the deductible. I think clearly the jury took into consideration the deductible, and the way the question was written was not, what are the contract damages? The way the question that the jury answered was written is, what is owed? And I think that is significant, because it's not simply what was the replacement cost. It's what was owed. And the jury, from the judge's initial statement of the case to the closing argument given by the appellant, was told about that deductible. And I think that the jury took that into consideration and awarded what they awarded as to what is owed, with no expectation that the deductible would be taken off of it, which from a rhetorical question standpoint, if the jury had awarded 230-something thousand, would they still be arguing that the deductible needed to be taken off? And I think the answer is yes.
Was the jury considering the deductible part of the loss?
I think that the jury made a decision, and can I swear to this? Do I have absolute solid evidence of this? No. But based on the note and based on what happened at the trial, I believe that the jury was paying what they felt like was owed for the replacement, not an amount that was going to be subject to the deductible. But it's really kind of interesting to hear on the Menchaca issue about the independent injury aspect of this, because I think there was independent injury. I think there's a question as to whether Menchaca even applies to this case. But I do believe that there is evidence of independent injury. And some of that evidence would include, as you pointed out, Judge Clement, that the issue of this interior damage, because this interior damage would not have happened in the long run if the claim had been properly paid. It's more in line with the tort damage. But also, I mentioned this substrate issue. I believe the jury was taking into consideration the fact that because it was pointed out at trial, because they cross-examined Mr. Hastings about the fact that it's the amount of the damage on the day of the loss. Because he had done an estimate that was in October, and trial counsel reiterated over and over again that it was the date of the loss, that amount of damage that existed. And so the fact that you had this damage from the water intrusion and the fact that you had this damage from the water saturation underneath the membrane and in the insulation, I think the jury was awarding damages for that, which they felt was an independent damage that wasn't covered when the loss that occurred on the day of the hailstorm.
Well, let's talk about the extra contractual damages. There were three categories. Three questions asked that were answered yes, and then three damages amounts, 57, 29, and 29. Was the church required to elect among those three things, or are those three separate claims?
I don't believe that they're required to elect.
I mean, isn't there, like, I'm particularly thinking of question 7 and question 9 in the jury instructions, and the underlying question about the, is church mutual liable? Isn't there overlap, substantial overlap between the bad faith question and I can't remember what the other question 7 was?
We'll really never know that, honestly.
Well, but I guess in other words, if there's overlap and the elements are the same, shouldn't the church only get one of those?
In my mind, and don't believe me, the math that you came up with, Judge Wilson, was done by me on the day of this verdict. The fact that they came up with 400,000 told me that the jury was considering different types of damages, that there was no overlap. Now, how did they come up with the 29,000? I don't know. I'd be lying to you if I said I did. The 57? I don't know. Now, counsel argued earlier that we believe that it was the amount of the deductible and the amount of the deductible times 2. We don't know that. That's just speculation. But in my mind, the jury was considering these other damages, and they made a compromise because some people on that jury didn't want to pay the full 804. Some people did, and by calculating the damages the way they did, took into consideration this insulation issue and the water saturation issue.
Well, but you'll agree, though, that they've got to have some basis for awarding damages, for example, for unfair and deceptive practices.
Right.
They came up with $29,000.
Right.
And then duty of good faith and fair dealing, I guess. So they said bad faith, $29,000. But I guess it's question 7 and 9 that actually ask the substance. There really seems to be a lot of overlap there, so was the jury double awarding?
I really don't think so, Your Honor.
Well, how do we know that? What supports your argument so that we can affirm?
Well, we don't know that it didn't. I mean, I don't mean to be flip by saying.
Well, no, that just means we defer to what they did and
Exactly.
period.
Exactly. Whatever occurred in that jury room, under our federal rules, I can't even ask. And so the logical conclusion is it was a compromise verdict and that they were taking into consideration these various types of damages to come up with a specific award that they felt compensated the church. That's really all I have. Any more questions? Thank you.
Thank you, counsel. Mr. Lane, you have 5 minutes.
May it please the court, I may not use all 5 minutes. A couple of notes. The ubiquitous cases I referred to at page 2 of our reply brief, there are a number of those that are listed, and what we found was when you search for those where the underlying damage found is reduced by the deductible, they will populate your Westlaw search. The bottom line is that no reasonable jury that took the deductible into consideration could have found that $285,000 was the amount of benefits due under the policy. Plaintiff's counsel just admitted, he said, well, it's just speculation as to how they came up with these numbers, but it requires something more in the face of a challenge to the sufficiency of the evidence to say, well, we can only speculate as to what it meant. I think it's pretty clear when you look at the numbers that were put into this verdict form where they came from and what they meant. There was $285,000 that came exactly from the estimate of the cost of repair, unreduced by the amount of the deductible, about which the jury asked during deliberations and was given no guidance. There was a separate award of $57,000, the deductible, in response to a different question, unrelated to any proof of an independent injury apart from the loss of proceeds. And then there were these two $19,000 awards. Again, there was no evidence. Again, Menchaca says that it's extremely rare that you're going to find an award of damages where there's an independent injury from the loss of the proceeds, apart from the proceeds. And the only case that we've seen that's been upheld in that circumstance is for mental anguish, which is not available to the plaintiff here and was not sought, obviously. We think that the issues with the verdict are rather obvious. They're easy to correct, and we would ask the court to modify the judgment and reverse and render a modified judgment that removes the amount of the deductible from the contract claim, that removes the unsupported extra contractual damages because there was no evidence that there was an injury that would be supportable as bad faith or under the insurance code. And thirdly, would reduce the amount of costs that were awarded against Church Mutual. And that really has to do with this rule that permits, there's a rule, and it often comes up if there's, for instance, a medical doctor who's going to testify and the defense wants to have the plaintiff's medical doctor, they have to pay for the medical doctor. It's not put on the plaintiff. That's why that rule exists. It doesn't exist to compensate the public adjuster or whoever for all of their expenses in preparing all of their testimony. And if you look at the underlying evidence, it doesn't support that award of costs. Unless the panel has further questions, that concludes our...
Very good. The case will be submitted.
Thank you, Your Honors.
We'll call the next case, number 22.